Yes, I'm aware of volume 3 because I saw it being prepared.
Are you aware of volume 2?
Yes, I'm aware of volume 2.
Are you aware of volume 1?
Yes, I'm aware of volume 1.
Has there been any other disclosure?
I have told you that I can't tell because we divided roles, Mr. Mpaka. For your information, you have not seen me in this court for some time because we took a decision that I personally stepped down and not another person. So
I am not part of it.
I'm informing you.
Thank you, sir. Would you look at volume 3 of disclosure? This is my stated copy. You are good at the deducted statements.
They are redacted statements, my brother.
How many statements?
6 statements.
Those are the 6 witnesses.
Yes.
All of whose statements are redacted.
Yes.
The reduction is to remove their identity.
And any information that would lead to their identity.
So you have disclosed information which is redacted by removing all manner of information which can point to their identity. Am I correct?
You're correct.
So essentially, you have come to this court to ask for an order for something you have already done. Correct? But you seem to know what the court will say.
My Lord,
you have done already what you are asking for. Am I correct?
this is just a specimen.
Am I correct?
You're not.
So are there other 6 statements coming? So those are specimens? Or those are the ones?
These are the specimens.
So you have done already what you want the court to order. Am I correct?
My Lord,
Am I correct? Can you give me my file?
my Lord,
My Lord, can the witness stand over? Would you read prayer number 1 in your motion?
the concealment of the identities and non-disclosure of any material that is likely to reveal the identities of 6 prosecution witnesses, witnesses A, B, C, D, E, F, E, A, B, C, D, E, and F, prior to their testimonies in court.
You go to 2.
The above 6 witnesses be allowed to use pseudonyms with pseudonyms, witness A, B, C, D, E, and F.
Go ahead.
And their true identities be concealed from the public record in all proceedings related to this case.
So do you agree that these statements conceal their identity?
Yes.
So you have, for you, done already what is this court? You ask this court for an order you have done already.
My Lord, it is court to agree with us or disagree with us.
Deducted statements before the court grants the order.
This is, my Lord, this is just a demonstration. It is just a demonstration.
Mr. Chomhe, would you refer to the forwarding letter? I I have returned to you my file again in the hope that you return it to me freely. Read the forwarding line.
The third disclosure by CID headquarters, E033 of 2025, Uganda versus Colonel retired Dr. Besigye and 2 others. Please acknowledge receipt of disclosure of evidence by prosecution.
Are those the ones which are redacted or redacted?
They are the ones. My lord, it is just logic.
Let me ask, I don't have logic, but I want to ask, where in the forwarding letter does it state that this is a mere sample or demonstration of what is to come?
It's not there.
You say that you are an advocate. Remember?
Yes.
For how many are standing?
15.
Do you agree that presupposing a decision of court and coming to court when you have already done what you asked to do is an abuse of process?
It's not. Maybe you're new to witness protection applications. Yes.
So you came for witness protection and you invoked the protection before court sanctioned it. Is that what you're saying?
We were just courteous.
Is that what you're saying?
We were just courteous to you, the defense. We wanted you to know that these statements and witnesses actually exist. But it would be futile for us to disclose the statements in the particulars, and then we are seeking to protect them.
I do thank you most sincerely for your courtesy. And now the question, do you agree that you did something before the court allowed you?
We've not yet done it.
Have you disclosed? Did that take statements before the court makes the court?
Subject to court ratifying or agreeing with our prayers.
You have come to court to ratify your decision.
I said subject to court agreeing with our prayers. Court may agree, court may not agree. It may dismiss the application, it may grant.
So
and where it is granted, it would be futile for us to seek protection, and yet we've already exposed the witness.
So you've done already what you want the court to allow you?
No.
Right?
No. We would say that if trial had commenced. But this is just the process.
Okay. Mr. John Handel, could you go to paragraph 4 of your statement? Sorry, affidavit. What does it say? If you may read it to the court.
The trial has commenced and the prosecution is in the process of disclosing the evidence and the identities of the witnesses to the respondents as scheduled by court.
So has the trial commenced?
By the time
Has the trial commenced? By your affidavit?
Yes, the trial has commenced.
And you did what you wanted, what you wanted to do when the trial was commenced, correct?
I'm saying no.
So the trial has not commenced.
The trial has commenced.
So you submitted the redacted statements after trial had commenced. Am I correct?
I can't recall exactly because I'm telling you I was not party to that.
11th March 2026.
The accused persons have not yet taken.
You say that the accused haven't taken.
I'm corrected. You see, I told you that it's been a long time. It's been a long time, my lord.
Mine is to remind you that what I said here is true and correct the best of my knowledge.
My lord, trial has
You
commenced.
didn't say recollection, no knowledge.
My lord, trial has commenced.
So do you agree that you have abused court process?
No, no, no.
In your view, you are saying that you can use this court to wash your decisions by seeking ratification.
It's not,
already done what you
it's
want.
not a ratification. Court is at liberty to agree with us. Court is at liberty to dismiss the application, but it would be futile for us to disclose statements with the particulars of the witnesses, and yet we seek protection. It would be futile.
I want to read to you some of what is contained in the redacted statement.
My Lord, I pray that he does not read the contents, because this is a witness protection. My Lord, this is a witness protection application. This is a public trial.
My Lord,
He wants to read the contents of one of the statements that we are seeking to protect, of the witnesses that we are seeking to protect. My Lord, this will prejudice.
My Lord, we were given the redacted statement.
Are you want to examine?
By a court order. By the court order. My Lord, when you pronounce yourself.
No, what I'm saying here, are you trying to cross-examine the witnesses?
No, I'm not going to review
So
it.
proceed, but
Because my Lord,
don't cross-examine him on the submitted witness statements.
they are not named.
My Lord, it doesn't matter.
It's fatal.
It doesn't matter, because this is a public trial.
Kindly, I have said, let him continue, but not cross-examine the witness statements.
In your prayer, you refer to witness A, B, C, D, E, and F.
Yes.
Have you read those statements?
Yes, I have.
You know the context.
Yes, I do.
Are you aware of the first statements that were disclosed?
My Lord, I beg not to go into the statement.
I have already said.
My Lord, no, my Lord. There are two statements. There are those which are redacted.
Yes, 6.
Yes. Then
Not
there are
cross-examine.
yes, my Lord. Then there is the first batch where they state the name, the rank, the telephone number. That's public information. So I'm asking you, are you aware of the first statements? There were 4
For statements that were what?
that were disclosed with the names of the officers.
My Lord, I told.
Are you aware of them?
I'm not. I told you that I was not. We divided rule. We divided.
I have finished that, so you are not aware of the witness statements.
No.
The index. The index here.
Yes. What should I do with it?
Give it back. You are aware that the index reads Lieutenant Colonel Queen,
My Lord, I pray
I think
that in as much as the witnesses are not protected,
Yes.
the nature of this crime
I have finished
and
that.
offense.
My Lord, let's get direction.
I am saying I have given direction that no cross-examination of the witness statements that have been submitted.
My Lord, if I can
Cross-examine him on his affidavit.
My Lord, if I may explain, the application is in respect of 6 statements.
Yes.
There is
Cross-examine him in his
I'm also ready, my Lord, only that if court could be said. The application has not been sold for the 4 witness statements. So the 4 witnesses already are not the subject of this application.
I've already said don't cross-examine him on the witness statements, even 4, which court has not had. Don't cross-examine him. Don't bring this evidence here. We are not in the trial.
I agree with you, my Lord.
We are not in the trial. Don't go affidavit.
Mr. Joseph, you see the names of the four and keep them in your heart.
Might not be still object to that kind of cross-examination when court has already made a decision on that. And I wish my senior colleague would hear my voice and sit down. We can't be two people standing. Yes. You can never be two attorneys standing in court. And I'm making an objection, my lord.
My lord, now you will sit down. When the counsel has a minimum level of courtesy. And when he does so,
I have guided that counsel panel proceed, but not cross-examining on the 4 or 6 witnesses, but proceed on his appeal.
is there any evidence in your affidavit that those who are known to the public have come under arrest? You point out in your affidavit. That's why I say have the names in your heart and you point out that in your affidavit.
Maybe if I can have the affidavit in return.
Which one?
For the first and second applicants. He didn't give me an affidavit. So I got from court, Mr.
This is the first. That is the second.
My Lord, I'm reading out paragraph 18 of the affidavit in rejoinder to the affidavit in reply of Hajj Mopet Internet.
Yes.
And there should be a corresponding paragraph for the first applicant. That in reply to paragraph 22 of the affidavit, the nature
Of which affidavit? Of Hajj.
this is for Hajj.
So we look at 22 of Hajj.
No, this is 18, paragraph 18 of
Responding to 22 of Hajj.
yes. The nature and gravity of the offenses that the respondents have been indicted with make witness protection inevitable. My Lord, given the nature of the offense,
My Lord, maybe I repeat your question. My question was, of the names of the individuals whose name, force number, mobile telephone, place of residence, and contribution in this suit, in this matter, is there anywhere in your affidavit where those whose names are already known to the public have come under threat?
paragraph 18 covers them.
Could you demonstrate, show us the threat, point out that paragraph 18? We are talking about gravity of the offense.
I talked about the nature. It is a high risk offense.
I'm not asking about the offense. I'm asking, has there been threat to the 4 officers whose names have been?
And I'm telling you
The
that
answer is
because of the nature of the offense, I cannot tell.
So does that long statement mean no?
It doesn't.
Have they sworn affidavits to state that they are under threat?
No.
Is there evidence before court that they have come under threat?
The nature of
Is
offense.
there evidence
Yes,
before court?
the evidence
Could you show
that
us
has
the
supported
evidence?
is disclosed to you.
Could you show us the evidence of the threat?
The nature of the offense, I'm told you, alone is enough.
Does
It is
the
a high
nature
risk
of the offense mean threat? Are they the
Yes.
same?
Yes.
So in your view, when we say treason is an offense of grave nature, that statement is the same as threat.
Treason in most cases involves use of firearms and retaliation.
Is there evidence of threat from the 4 officers?
Yes. The nature of the offense makes them automatically vulnerable.
So, do you agree that despite the fact that they are under threat, this application does not cover them? Do you intend to hang them out there?
For now, it is not covering them.
Why didn't you cover them in the police station?
Because at the time of deponing this affidavit, no threats had been registered.
When was the disclosure?
I told you I can't record.
When was the affidavit sworn?
The affidavit was sworn on the 31st day of March 2026.
By a member of the prosecution.
Yes, please.
And at that time there was no threat.
At that time, no threat was reported. As of today, I'm not completely sure.
You don't know. Do you agree that if you were sure, you would have sought leave of court for a supplementary affidavit?
True.
So that if you did seek leave of court, there is no such threat.
I can't say no because of the nature of the offense.
Did you refuse to apply for the affidavit because you intend to hang them out there or because there is no threat?
It is not that we want to hang them out
So
there.
it's because there is no threat.
Because there is no, because no threat has not yet been reported, it doesn't mean that they are not threatened.
So you feel that the individuals are threatened, but those who have been threatened have not reported.
And I'm telling you,
Is that correct?
I beg your pardon?
You feel that the individuals are threatened, even though they haven't reported. Is that correct?
Yes.
So you know before they report.
I've told you because of the nature of offense, yes.
My lord, I think this is where we should go.
You want me to mention the name?
No.
This is where we should go.
You have
looks like my senior colleague has run short of questions. Others will stick on the people who are part of this application.
My lord,
The 4 and the others are not part of this application in any case.
my lord, for
And the court has made a ruling on that, my lord.
For example, I'm on page 4 of 8 pages. So I haven't rushed.
That's a very bad question.
You have a list of them there. Yes?
Yes.
Do you agree that of the list of 4, don't disclose the names, none has reported to the FBI? Otherwise, it would be here.
The nature of the offense
You
is
agree
threatened.
that none has reported to you.
No threat has been reported.
Witness protection. Entails the protection of victims and their witnesses. Correct?
Victims are witnesses.
And I envisages protection of victims and their witnesses.
And I'm telling you, victims are also witnesses.
I am aware of your white notice, but please answer my question. Witness protection is protect victims and their witnesses. Correct?
Witness protection envisages protecting every person who is cooperating with the state to testify in a given case.
That includes you,
Am I a
because
witness?
now you're a witness. I'm not aware. You are testifying. You are now a witness. Does that include you?
I'm a prosecutor.
Testifying.
I'm a witness.
Now.
Ada nggak
Confirm to court. And going back to the start, that despite your earlier involvement with A1, right from the time of walk to work, even now when you're witness, no threat whatsoever has been reported by you.
I reported.
By having caused you, and no such report is before court.
My Lord, I pray that issues of my security be left out of the public domain. I pray.
It is as if, my Lord,
Mr. Mpanga, you don't know what we go through, you don't know what I'm going through.
you sit down. My Lord, it is with some prayer that our senior colleague desists from personal cross-examination of the witness because it's not here on personal issues. That's why we said if he has run short of questions, he better stops. He should stick matters which matter this matter in court.
I insisted that we refer to the evidence in support,
My Lord, and Mr. Wilbumuka alleged here in a snotty voice that they are crossing the red line.
Yes, of going too personal with the witness in court.
I have finished that.
What I'm asking the witness, my Lord, because this is witness protection, is where he has, there is evidence before court of him having been threatened as a witness. It's a simple question. There shouldn't be emotional.
We pray doesn't answer that question.
My Lord, let me explain.
Why?
My Lord, issues of my security, I pray should be left to me. Because he wants me to divulge.
I have said, don't go to the security issues, let us go to the evidence. You respond.
My Lord, my colleague, Mr. Katumba, same mistake.
My Lord, I stand to maybe refer to the court why the questions are being asked, so that the court can get the perspective that we have.
Kindly go to the question.
My Lord, why I ask is that,
Do you have a question?
my Lord, we have a question, but my Lord, so that the court understands the way. My Lord, we request kindly so that the court can get perspective.
Is he cross-examining?
My Lord,
Go ahead, please.
just not my Lord, that where the court takes the view that counsel can intervene and stop and ask the court to stop a witness from being cross-examined in a particular area, that right will be available to us, and the court will make a pronouncement without taking our views, however objective. Because, my Lord, what court has just done is stop us to guide you. That's why I'm saying that, my Lord, that when that opportunity comes, we hope that the court will not cancel it.
There is evidence of evidence to support, evidence to intrigue, and we order the witness to come.
And my Lord,
So proceed and
my Lord, I am not aware that in cross-examination I cannot ask any area around the subject.
I said the area don't go to the evidence of witnesses that have not come to testify.
But my Lord, that's the answer I'm saying, that what Mr. Katumba is saying, that we are asking the witness who has come to testify. He's
there.
That's why I'm asking him.
Proceed.
Has he reported any case of threat against him? It's a simple yes or no. Is there any police call?
And we pray he does not answer because, yes, he doesn't have to. Wait, can I submit? The witness is before court, not on a personal matter. He's not a victim, in which case my senior colleague would be eligible to ask such questions. He's a witness who came in contact with this matter by virtue of his job. And as such, personal matters do not apply to him.
Provided with examination in respect of this application. Maybe I should come to this table. Let's give them my lord, in cross-examination, let us go the line. My lord, I need not to say that cross-examination can be stretched as far as one can go, as long as what is being raised is within the context and is relevant in the case. My lord, I just want to conclude the case. These two aspects, my lord, as we have listened and we pray that, my lord, you revisit this matter. This was examined what?
Yeah, these two aspects
Yeah,
Mr. Manga was raising.
Yes,
One,
yes.
the 6 witnesses, their statements which were given to us, which were discussed and furnished to us, have been made reference to by Mr. John Henry in his affidavit. So once he brings in those statements and they are canvassed in his affidavits, they are perfectly within the realm of cross-examination, because he is the one who made reference to witness A up to 6. That is one aspect. The second one, my lord, is about the issue of his, the threats to him. The threats to him as a witness. Yes. That issue is equally pertinent because, my lord, he is in the dock. He is a witness. He chose to testify on investigations that he did not conduct himself. I was concluding, my lord. He said there is a report. I was just substantiating on the second aspect. When he was cross-examined on the arguments in paragraph 8 about investigations, he said there is a report. So he chose himself to report to testify on matters contained in the report. And he said, no, for him he does not fear to expose himself. But those ones who conducted the investigations cannot feature in the proceedings. And that's why, my lord, when he came to mercy, you ask him to prove that mercy, so that his identity is very clear. So there is no threat whatsoever to his security once he is proved. And that's why he arraigned himself here. We pray that, my lord, time most of that.
I am saying now, my lord, that the witness can be cross-examined anything, but not going in the evidence in the statements of the 4 which were submitted, not the evidence of the 6 which were also submitted. But cross-examined, we are motion.
Dr. Muhendo, I want you to read the affidavit to describe of article page you tell me.
appearances in this matter have been held in public and handled by public officials. The judicial officers who have presided over the various stages of the case and matters that have arisen are well known with their identities and workplaces in the public domain. Cause lists and rulings including but not limited to, I beg you not to mention the names.
No, they are public.
Public, but this is a public trial, my lord. I don't want to expose them further.
They are, my lord, they are an affidavit. I must need to read the affidavit.
This affidavit is within
Have you
ourselves.
refused to read the affidavit?
I have recorded that as no read.
My lord, not that he has not read, that he has refused.
You can put it in the submission. My lord, the advice is candidate for submission.
33, my lord, the names of the judicial officers. 33, my lord.
My lord, can I read them to the court?
No.
My lord, these are judicial officers.
The names, eh?
Yes.
My lord, take note of paragraph 33. Please. Affidavit of Haji Obey. And paragraph 37, the affidavit of retired Dr. Idris. No, affidavit in red flag. Followed by A1, paragraph 37. Affidavit in red flag. A1, paragraph 37. 37. My lord refers to the judicial office. And paragraph 33 of Haji Obey.
The first one is paragraph 37.
Kano, Miguel Kano.
And then we do paragraph
33 of Haji Obey.
So go ahead.
Now, my lord, I'm going to refer again now, paragraph 38 of the affidavit of Kano retired. 38. And then paragraph 34 of Haji Obey. My lord, those paragraphs make reference to the person 34 of Haji Obey. 34, my lord. No, I think I'm sorry. My side is very organized. 34. And my lord, I'm saying that those paragraphs make reference. I'm asking a question.
I have read it.
Do you agree that those
Go ahead
paragraphs
with the question.
make reference to the judicial officers
Yes.
and the prosecution team that has handled the matter? Read 34. 30 minutes. Not just give reading.
My lord, I can't read out in the open.
So from here, I am here, then you are here, then question and answer. Correct.
Are you there, sir?
Yes, I'm there, sir.
Have you read on? Memorized?
Yes, I have.
You responded to that paragraph. Correct?
I need to refresh my memory.
Look at your affidavit.
May I have a look at it just the same time? Then paragraph. Paragraph one, number one.
My lord, let him beg.
I need to know what happened. I have over 10 paragraphs here.
Yes, ask the question.
I want you to ask this.
He's reading one.
Which paragraph?
I also want to read.
Paragraph 30.
That paragraph 33 of the applicant's affidavit is speculative.
And then the next.
The further replied paragraph 33, the second article of the second applicant's affidavit, use of pseudonyms, body length disclosure will not delay the trial.
So, in regard, when the respondents state that the judicial officers and the protection people has handled the matter has not come under any threat because you are part of the team. Your response is that it is speculative, correct?
It is speculative
Have
because you don't know what we go
Let
through.
me just explain. Have you demonstrated anything in the affidavit to confirm the basis of speculation?
It is speculation
Have
because
you shown anything in your affidavit you rejoined that to say for the mere assertion of speculation?
I said it is speculation.
Mr. Chonghen,
The word itself is sufficient.
I know the word and I have read it.
I cannot investigate a speculation.
So,
And you don't know what we go through.
So, can I state that your statement is without basis of any investigation?
In regards to,
This what you state in paragraph 30. You state that it is speculative without any scintilla of investigation.
this we are dealing with.
Am I correct?
No, you're not correct.
Where is the investigation to confirm that these are speculations?
We can reach out to the security agencies.
So it is not before court.
Not every threat comes to court, sir.
I don't care which one. Is that
Neither
one
do I.
before court?
Which
is
one?
the one which you are alleging speculation, those reports before court?
My lord, I cannot answer on behalf of the judicial officers.
I'm asking you,
And-
you're part of the prosecution team. Is there anything from the team that is before this court?
My lord, I cannot disclose my security issues. Mr. Mpanga, you don't know what I go through.
I am asking about.
You know that technically. Say yes or no.
Is there anything upon which you're relying on to confirm this court, to tell this court that these are mere speculations, apart from the mere assertion?
In regard to what?
In regard to your response in paragraph 30 and 29, what were you responding to? Threats to the public officers and the prosecution. Did you respond to attack that assertion that there is?
Now you want me to tell you, okay, I've received
I
threats in
am
the past.
referring to your affidavit.
Which touches that I've never received any threats? I've told you I've received threats in the
You are
past.
supposed to provide the
That's what I'm telling
You
you.
have the question and the answer.
So do you
Answer
confirm
the question as they put it to you.
that there is no evidence, yes, there is no evidence to support the view that the assertions of the respondents are mere speculation regarding threats, public officials and the prosecution team?
Am I party? I can answer for myself. Personally, I've received threats.
So that the other one you don't know.
The others I don't know.
Answer it that I did. Don't have to.
And confirm that the threats have been kept to yourself. They are not before court. The record there.
My lord, this is where we are going wrong. Can I just say something?
But we cannot guide the whole. I said the person no, or
I'm just saying this.
so but from being a busy boy. Let us. I am able to detect Mr. Man. I am able to detect the question and answer. So yes, I need question answer.
My lord,
And the other you can give it. Yes,
my lord, I am aligned with the court's view. My humble prayer is that the witness is also aligned.
you should
Most of
answer
them.
the question.
Mr. Jongheso, the matters before the capital in support, you say are true,
Yes, they are.
correct?
Yes.
So much so that if anything therein is false, you'll be telling a lie. Am I correct?
Not necessarily. I may misconceive a fact,
Yes.
if at all,
Yes.
but not a deliberate lie.
When something is not true, what is it?
Untrue.
What is something?
It is untrue.
So you agree that when something is untrue, it's false.
Not necessarily. It all depends on my perception of a certain fact.
Do you agree that when something is untrue and it is based on fact, it is a lie?
Not necessarily.
So you can tell a false fact which is true.
I may be mistaken, and I don't tell a deliberate lie. Yes.
So there is a deliberate lie and an undeliberate lie on oath. Am I correct?
No.
So what is it?
I did not tell any lie. To the best of my knowledge, my
So
lord.
everything you stated herein is true.
Yes, it is.
Paragraph 2. Unlike before,
What, my lord, you want to follow?
my lord,
Paragraph 2 of what? We want to follow the cross-examination.
the material person can
Yes, but we need to follow. Even your colleagues need to follow.
We are really
don't
don't
know.
know. Simple.
My lord, me, I've just presumed that it is my affidavit in support.
you are a right man. I'm right. In paragraph 2, unlike what you stated before, you now confirm that these people have been in Buzira. So when were you lying? When you didn't know or you didn't?
My lord, according to my affidavit, I stated my facts right from if I may read out paragraph 2, that I'm part of the prosecution team of High Court criminal case number 008 of 2025, where the respondents are indicted in prison and misprision of prison, contrary to section 23,
Yes.
1C and 25
Yes.
of the Penal Code Act,
Yes.
and they are remanded at Upper Prison, New Zealand.
Earlier you didn't know.
Because, my Lord, this was not brought to my attention, and this is an affidavit I did on some time back.
So do you agree that the other one that you don't know was a lie?
It's not a lie per se.
You said you don't know, but you know.
At that time, I hadn't read through my affidavit, but now I've read through.
Do you also agree that in this court there is no High Court criminal case number 8 of 2025, Uganda versus Besigye, Ajobe Tutale and Captain Ola? Or again you didn't know?
My Lord, this number must have been, was got from,
Mr. Chomuhene, is that number correct?
according to me, it is correct.
Would you go to the titulation of the application? Titulation means title.
Okay.
First application number 101 of 2026, arising out of
High Court 0335 of 2025.
So are you here in regards to 008 or is 008 not true?
My Lord, maybe the numbers,
008 true.
the numbers could have changed.
The court told you to answer yes or no. You are making these things, so I should have finished a long time ago. Just have the grace and see if it can true. But now you're going to page 19 when
May I please go through the document?
no. I want to.
No.
They want to ask you.
My Lord, I'm entitled to cross-check the entire title of the document.
My Lord, I've asked about paragraph. Simple.
My Lord, what I captured here is 008 of 2025.
And is it true?
Only court can correct me, sir. If my number is wrong or not.
That is very true.
Only court can correct
When you read the top,
you're not court. You have your number, I have my number.
and I'm referring to numbers in the document.
Yes.
So which one is wrong, which one is correct?
I don't
In your document.
Only court can correct me. I don't know.
So can I say that in paragraph 3, when you say that I'm conversant with the facts and evidence of this case, because the number is a fact, you are again telling a lie because now you're saying only the court can correct you. You don't know.
I'm referring to the case that is before
No,
this
I'm not
honorable
going
court
to
now.
And you say
I'm not telling a lie. I'm not telling a lie.
paragraph 5. Are you there?
Yes.
Do you agree that there is no evidence of any personal violence in this affidavit and in Annexure B, which is the indictment and the suspect?
My Lord, that would have to take me to the evidence. Yes. That would take me to the evidence that would really jeopardize.
No. I asked my Lord, remind the witness. I asked him and he confirmed that in this application, the evidence is in the affidavit, annexures only. This application is not the main trial. It's an application on its own. And he said that if an affidavit is short, it doesn't merit the benchmark for. Do you agree, paragraph 5, that there is no evidence whatsoever of personal involvement of the accused person, personal violence, in the affidavit and even in the indictment, which constitutes the evidence to support the conviction?
My lord, the indictment is accompanied by a summary of the case, and I wouldn't want to go into the merits of the case, my lord.
Did you,
My question is, do you agree with those?
did you show, yes, did you show any personal violence attributed to the accused person in the affidavit?
It will come
The
out
problem
during
is
the trial.
answering before the question. That's why you are messing up.
It
In
will-
the affidavit, in the indictment, and in the summary, do you agree there is no line or anything of personal violence?
the nature of the offense. Prison is naturally a violent offense. It involves personal violence. It involves violence against citizens.
And aware that it involves personal violence, you still fail to demonstrate any personal violence of the accused. Am I correct? In these documents.
Because this is just a summary, and the facts will come out during the trial.
So do you agree that in this application, there is nothing to show personal violence?
And I am telling you that
You are wasting time. My lord, I think there is.
I'm answering.
You have it. Can you show us where you demonstrate personal violence?
Yes, I agree
That there is no violence.
that there is violence.
Would you show us where you
The nature, the paragraph itself speaks for it. The paragraph speaks for
Let's
itself.
go step by step.
Yes,
Okay? There are 3 accused persons.
yes.
Would you first of all show the personal violence attributed to Haji Obedi in the affidavit and the indictment and the summary?
My lord,
Could you show us?
I've told you the nature of the offense.
That's not the question. That's why I asked, do you agree that in the affidavit, in the indictment, and the summary, there is no attribute, there is no proof of personal violence? Haji Obedi.
I told you I don't agree because
Are you saying there is attribution of personal violence yet it's not there?
my lord, I'm saying it's there because because paragraph 5
So it
speaks
is
for
there.
itself.
It is there. Yes?
Paragraph, yes. But I told,
Would you point to it?
the nature of the offences with which the accused persons are indicted are serious, grave in nature, and also involve personal violence.
So your application hinges on a number of attributes. 1, the nature of the offense
Yes.
and personal violence.
The application?
No. The remedy sought.
On top of the nature of the offense, we have real threats.
Have you demonstrated, now you're taking us to threats and still at violence?
Because you are also summarizing the entire application.
No. Do you agree that there is no personal violence?
I agree that there is personal violence.
You show us the personal violence. One of Kanoki's Besigye and Obedi Tani.
I have read several paragraph 5. I say that paragraph 5 speaks for itself.
So can I take it that apart from the assertion in paragraph 5, you have failed to point court to the particulars of personal violence?
I've not failed, I've pointed out
If you haven't failed, can you show them to us?
paragraph 5. My Lord, I pray if it's possible I can take a seat for some time. Is that the chair? Yes.
don't know, sorry. Because the answer was here and there.
He said he has pointed out in paragraph 5 that there was personal fight.
My Lord, because I asked the following question.
Well, repeat it so that
You confirm that despite the mere assertion alleging personal violence, you have not shown in this application evidence showing the particular attributes of personal violence associated with the kind of Besigye and hypothesis.
Yes, I'm relying on paragraph 5.
So apart from the mere assertion, there is nothing else.
No.
When we go to paragraph 7, from the application sought, the 6 witnesses have not been disclosed. Correct? I'm not going into the...
I told you that I've not been invited to the disclosure. If they've been disclosed, you can be kindly.
No. You are you got paragraph 7. You refer to the 6 witnesses, Mr. John. If they are disclosed at this stage, their lives and their loved ones will be in danger. So they have not been disclosed. You saw this affidavit. Second one.
Yes.
So, when you say there is a security threat, that is factual.
Yes, it is.
So, your evidence is that despite the fact that the identities have not been disclosed, they are threatened. Correct?
Like we said.
Is that correct?
Yes, it is.
Do you agree that the 6 witnesses are not known to the accused persons?
They are known.
The identities are not known to the accused persons.
Some of them are known. They are actually, some of them could be known. That is why Mr. Chehere.
Let me demonstrate.
Yes.
Mr. Chinyere, first of all, is not part of the 6 witnesses. Correct?
Correct.
So, I might know Mr. Biribunga because I do know him. I might not know that he's coming to testify against me. You get it? Joseph, you follow?
Yes, I'm following.
So, the keeping confidential
Yes.
is that you don't want the public to know
Yes.
that these people are coming to testify.
Yes.
Correct?
Yes, correct.
That means that the accused persons do not know these individuals coming to testify against them. Correct?
My Lord, if
Is
I
that
may
correct? Remember what court told us. You answer.
My Lord, if I may read the paragraph. Paragraph 7 reads that there is a security threat against the 6 witnesses who are subject of this application, and if their identities are disclosed at this stage, their lives and that of their loved ones will be in danger.
Absolutely. So when you said there is a threat, that is a fact. Am I correct?
Yes, you're correct.
But the individuals against whom they are coming to testify don't know them. Correct?
My Lord, I can't tell because whether the accused persons know them, we refer to other accomplices. It's not about.
I am looking at paragraph 7. You are wasting time. I will come to Mr. Chihere. Paragraph 7. Please read it.
Okay, I don't know whether the accused persons know the witnesses or not.
So, is there a threat?
There is a threat.
So, is it your evidence that the accused persons or their accomplices are threatening people they do not know?
I have told you.
Is that your evidence?
I have told you. And for the accused persons, I have told you I don't know. But as for Mr. Kihere, he knows.
Mr. Chombe, because I want to finish, I call it. Do you agree there that paragraph 7 is a lie?
It's not. It's not a lie.
Is it plausible that I can threaten someone who I do not know?
You can do so through agents or accomplices.
Have the 6 witnesses known that they are coming to testify?
Known by who?
By those friends.
As for the accused person, I don't know. But as for the accomplices, at least we are sure that they are being threatened.
So, you are saying apart from the accused person, other people know the 6 witnesses.
That is why they...
Am I correct?
That is why they are being threatened.
Am I correct?
Yes.
So, if I am correct, you are asking court to hide the iPhone in order to hide the identities of individuals who are already known. Am I correct?
My Lord, he's not. My Lord, he's not correct. He's not correct because this is a racket. It is not 1, 2, 3 people. The moment the documents go out to the public domain, the threats will increase.
Let's be practical as lawyers. Okay? The reason you want to use the practice to get confidential, right? Is that they are not yet in the public domain. Am I correct?
They are not yet there.
So if they are not in the public domain, they are known to the prosecution team.
Yes.
Not the public.
Yes.
Correct?
Yes.
So the threat can only come from those who know them.
Not necessarily. Not necessarily. No. The moment the documents are disclosed and they go out to the public domain,
Yes.
others will also join.
So you are saying that the others will join the threat posed by those who know them. Am I correct? Am I correct?
We shall only widen the racket
Yes, that they are now threatened by those who know them.
by Mr. Chirehe.
You are threatened by Katumba. If Mr. Pilpumbuka also knows he will threaten you, God forbid.
No.
You get it? Do you understand that?
I get you.
So do you agree that the matter is between the state and the accused person? That the accused persons cannot threaten someone they do not know. Do you agree that, generally speaking, you can't threaten someone?
They have agents.
Do you agree?
Sorry? I can threaten someone I don't know. Through another person. Through another person.
So,
Kindly, can we have order?
you don't know that person because their particulars have not been disclosed, correct? Then you go and threaten that unknown person. Does it make sense, Mr. Chombe?
It makes sense. It does. I can threaten you through another person. Yes.
Have you brought any report to show that Frank Chihehere is an accomplice to the respondent before this one?
The nature of the application does not allow you to.
That's what I'm asking.
I've not brought a report.
There is nothing to show that Frank Chihere is an accomplice.
My affidavit is there to show.
Your affidavit is not a report.
My affidavit is evidence, right?
Yes.
Yes.
But which evidence alludes to an investigation not backed by report?
My lord, my evidence is my affidavit.
Yes. You recognize that your evidence in that respect is shallow.
It's not.
Where is the report?
My lord, we could not attach the report because it would be exposing the witness further.
Do you agree that in the absence of a report, when there's been an investigation, the matter has become speculative?
No.
They remain solid
No.
in the absence of the report.
That is your view or opinion.
No, I'm asking you.
I don't agree.
So, do you agree that time is necessary in preparing for your defense? Time is a key ingredient for an accused person to prepare for their defense.
Yes.
And that in an offense of this nature, with the volume of the disclosure, you need sufficient time.
Yes, I need sufficient time which I can get from court, which I can apply to court, and it grants me the time.
So do you agree, in your view, that despite the disclosure made, 7 days is not sufficient time?
7 days is sufficient.
Could you tell us the basis, in light of the disclosure made, how 7 days is?
7 days is sufficient time for me, for my lawyer to read through the statements and interview me, interview my relatives, if it's necessary, within those 7 days.
In a treason case?
Yes, but if it's not sufficient,
In a treason case?
yes, the timelines can always be expanded by court.
So is the time you asked for sufficient?
That is court. It is court to determine. Yes, it is.
A champion of justice.
It is. Yes.
Do you agree that paragraph 7, 8
Of what?
of your affidavit in support and 10 are not backed by fact?
They are backed by fact. The paragraphs stand on their own and support each other.
The paragraphs are assertions.
No, they are not.
And that's why when we cross-examine you,
They are not.
you fall far short.
I said the investigation revealed that Frank Chihere, who is an accomplice to the respondent, threatened to harm one of the witnesses in this matter.
And we agree that he's not here.
He doesn't need to be here.
Not the report.
The report is not.
So,
It is part of our
so
of the
paragraph
evidence.
8, there is even nothing to confirm that there exists a person called Frank Chihere. Because at least you would have brought...
I've told you in the affidavit.
Hold on. You would have brought his ID because he's the threatener, if I call him that. You have not demonstrated that Frank Chihere exists. Am I correct?
Mr. Mpank, I knew you even without seeing you. I don't need to see you physically for me to know that you exist.
Do you have proof that Chihere exists?
Yes,
Where is he?
the report.
Where is he?
The report.
Despite being a champion of justice of 17 years standing,
Mr. I didn't say it's 17.
15,
Yes.
you gathered to annex your identification to show that you exist, correct? Correct? The only one you brought is to show that you exist.
Not really.
You brought it for leisure.
Just the title. for you to confirm the title.
So do you agree that we need to confirm that he had?
You will confirm during
this
the
application?
You will confirm.
So, to the extent that we shall confirm in future, do you agree that in the immediate, his existence has not been confirmed?
It, according to you, but according to us, and paragraph 8, Mr. Frank Chihere exists.
Okay. Before court, his existence hasn't been confirmed.
It has been proved by paragraph 8.
Do you agree, as a champion of justice, you have read the case, you have cross-examined, you have prosecuted, that the identity of the witness is material, determining, among others, their capacity, credibility, existence, truthfulness.
Which particular witness?
Any witness. When you are conducting the case for the state or for the defense, the identity of the witness is material to the preparation of your defense.
My lord, it depends on the
Am
nature.
I correct?
You're not correct.
I'll rephrase the question.
But he has answered it. Does it have to rephrase it?
Okay, I'll ask another
Maybe ask
question.
another question.
Is there a case when in your say 15 years practice where the identity of the witness is immaterial to preparing the defense?
I've not understood.
From your 15 years of practice, have you come across a scenario where the identity of the witness is not necessary, is immaterial, is unimportant?
Under what circumstances?
Preparing for your case.
But I told you that
Have you come across this? That was my question. Remember what the judge told you. Answer the question.
I don't know what type of witness. You're talking about a defense witness, you're talking about prosecution witnesses.
That's why I said any witness. Remember, you are an advocate, a lawyer, you're a seasoned attorney, you even alleged you are an expert.
I told you that I've never, this is the first application.
My question is,
Yes.
in those many years of practice,
Yes.
where you have moved, and my lord, it is important that I read to Mr. Chomhendo what he goes by. You placed yourself as a champion of justice, and in the phrase you put there, you say, I am 10 times the prosecutor I was in the past. Meaning that your expertise has increased tenfold from the person you were. In that expertise, have you come across a scenario where the identity of the witness is irrelevant in preparing your case?
You see, I'm still not getting the question. We deal with physical witnesses. We don't deal with virtual witnesses.
I have not talked about virtue.
Yes.
That's why I said identity. Because even with the virtual witness, you have the identity, the particulars. You have the name, you have the sex, you have the age, you have the place of residence, you have what you do. It is, have you come across a stage when those are absolutely irrelevant to preparing the case? Call it the defense, call it the prosecution.
Identity of the witness is important.
It is important.
Yes.
So do you agree that by removing that identity, you are impacting on the right given to the Constitution, given to the accused, to prepare their defense adequately?
No, I don't agree.
So your evidence is that even if identity is important,
Yes.
it is not important to Kiza Besigye and Obed Mutale.
Because this type
Am
is...
I correct?
Sorry?
Before you give me the reason, am I correct? Identity is important for all others, save Kiza Besigye and Mutale, because
where it is regulated by court, court can regulate.
In the absence of regulation, is it important?
I have said at all times, it is important, but court can regulate.
So it is the first point you recognize is important to them.
It is important to them, but
Have you
court can regulate and balance that rate,
and court will regulate when you demonstrate circumstances
like we have.
in which you can intervene?
We have demonstrated the circumstances.
As I cross, in which paragraph?
Read the entire affidavit.
No, in which paragraph?
The entire affidavit.
No. In which paragraph?
The entire affidavit. You read.
You can't point to any paragraph.
You know the paragraph.
No, Mr. Jomuhendo, my colleague has asked me because I'm finishing. My Lord, I want to finish, and there are only 15 paragraphs. I want you to show me which of the 15 paragraphs are aware that 15, 14, and 13, you state the basis of what you signed. Be factual. Paragraph 1 talks about yourself. Paragraph 2, your role in the scheme. Paragraph 3, your knowledge of the facts. Paragraph 4, the commencement of the trial. Paragraph 5, the nature of the offenses. So it must be between 6 and 12, where you have demonstrated, so that court can say, under this paragraph, Mr. Jomuhendo demonstrated.
My
Just
Lord,
point to the paragraph.
all the paragraphs.
Even 15.
Yes, even 15, because it is affirming that I saw the affidavit in support of the application.
My Lord, I'll finish now with my colleagues. For now, my Lord, I might return.